Good afternoon, everyone. Delighted to be here and to see so many people online, as well as the people that are here in person. My name's Laura Little, and I am a professor at Temple Law School in Philadelphia. And I'm honored, absolutely honored, to be one of the advisors to the toolkit and to be moderating this panel, this very august panel of our impressive co-advisors. So my approach today will be to, I first want to introduce each of them, and then I have a question to pose to each of them individually. They're going to speak for 5 minutes, and then for 5 more minutes, we'll open it up to the entire panel to discuss the particular question. Once we've been through the panel, then we'll have some time for question and answer. So to introduce our panel in alphabetical order, I start with Justice Stella Anukam, who is a national of Nigeria. She was elected judge of the African Court of Human and People's Rights in July 2018. She was recently re-elected for another 6 years in July 2024. She serves as a member of many professional bodies and has many leadership roles in various groups, such as the International Law Bar, as well as the African Bar. Next, we have Mehdi Benchelah, right, who is a senior project officer at UNESCO and is coordinating the rule of law, policy, and freedom of expression team within the section for freedom of expression and safety of journalists. He coordinated the Judges Initiative, a global strategy for the judiciary, systems on freedom of expression, access to information, and safety for journalists. Barbora Bukovská is from a NGO, Article 19. She's the Senior Director of Law and Policy, and she's had that role since 2009. She leads on the development of Article 19 policies and provides legal oversight and support to legal work across the organization. She has extensive experience working with various organizations on a range of human rights issues, including protection from discrimination, access to justice, deprivation of liberty, and reproductive rights and community development. And we have Judge Darian, who is a judge on the European Court of Human Rights. He was elected with respect to Albania and has served since January 2019. Before joining the court, Judge Pavli had an extensive human rights law practice. His work maintained a focus on freedom of expression. So please join me in greeting the panel. My first question is for Judge Pavli. And it concerns the challenges of sitting on a sort of transnational court or a regional court in balancing the particular international principles that the court is responsible for enforcing, as well as, in the context of humor, the particular sentiments with regard to the appropriateness of humor on a national level.
Thank you. And let me start by saying that it's been an extremely interesting couple of days being part of this discussion. I think I can say that the group has sort of taken the approach that protecting the right to engage in humor is quite a serious matter. And as a matter of free speech, and the ability of humor to play a whole range of roles in our public discourse, from the merely entertaining to the more subversive or political or social discourse vehicle. To come to the immediate question, it is a challenge. An international court or regional court is a bit of ad hoc animal, and even though there is a temptation to always think of it as a top national adjudicator, of course, the nature of the cases that come to the two kinds of courts can be quite similar, but the function of an international court has certain specificities. How do we deal with humor cases which can be very contextual? Well, I'd like to think that at some level the ability to appreciate humor is rather universal. But of course, it often, not always, but it often requires a particular background, a particular familiarity with the context, and some forms of humor can be quite niche. How we deal with it, well, for the most part, as a starting point, we have to rely on the findings of the national courts. That is always a starting point, especially on matters of fact and evidence and the understanding of the context, the overall context of the case. That can be quite helpful. And this is also tied to what, at least in the jurisprudence of my court, the European Court of Human Rights in Strasbourg, is known as the margin of appreciation. We need strong reasons to second guess the factual findings of the national courts or the interpretation of national law. Of course, when it comes to the convention standards, we have greater leeway. We also have the benefit, at least this can vary from court to court. At my court, we have the benefit of always having a national judge as part of the hearing of any case. So in any case involving Albania, the national judge elected in respect of Albania has to sit, and if he or she is unable to sit for any reason, there will be an ad hoc judge from a list of judges who will be another Albanian judge, in other words, who will be hearing the case. And it is part of the function of the national judge to help the colleagues understand in a neutral way what the case is about, what is the particular context, and so on. We also, the lawyers working on the case also tend to come, not always, but typically, they tend to come from also that jurisdiction. And these are all factors that help the full judicial formation, a chamber of 7 judges or a grand chamber of 17, to understand, to borrow from the title, what exactly is in the joke subject to that case.
Great. And now I'd like to open up this question to the entire panel. If anyone has a particular comment on what the judge just outlined, what Judge Havel just outlined.
Specific.
All right, I'll move on then. Next is Justice Anukam from the African Court on Human and People's Rights. And I have a similar sort of question in that as a judge on a regional or indeed a continental court, how do you deal with the context-specific nature of humor, including especially that humorous speech could offend some cultural sensitivities given a certain national context, but not necessarily all of the nations that are included in the representation of your court?
Thank you. Thank you very much, Madam Laura, for that question. Before I start to answer the question, may I also join the judge that just spoke before me to commend the team for a job well done. Indeed, I was very, skeptical when I got the invite and the topic and the issue to be discussed, which is humor, and I wondered what does humor have to play in freedom as a right. as part of the freedom of expression. But I think I have a clearer and a broader view after 2 very intensive days of discussing the topic. I do really appreciate, and I am grateful for the opportunity to be a part of this. From the African Court's approach, and in answer to the question, I would just like to say that in the African context and in the light of the African Charter on Human and People's Rights, I think we can appreciate that question. And I think in answering it, I want to say that the freedom of expression, indeed, and also freedom of opinion and the rights of journalists is well covered in the African Charter on Human and People's Rights. Indeed, Article 9, sub 2 of the Charter makes provision and does recognize the rights to freedom of expression, opinion, and the rights of journalists. And but a particular subsection of that article, Article 9.2, says that right must be exercised within the law. And within the law has been interpreted to mean within the international law. And that has guided the court over time in the handling of cases that come before it regarding the interpretation and application of that particular article. So we are not going to reinvent the wheel when it comes to humor, which is another way of expressing your opinion. I want to believe strongly that though the matter relating to humor has not really come before us directly, but when it does come, we are going to apply the standard that's already been set, the precedent that the court has set over time. And we have numerous cases where we have had cause to examine applications that have to do with freedom of expression. We have, if time will permit, or maybe, I don't know if I have much time, I will have cause to refer to some of the cases. And when we have a similar situation, I believe the same thing would happen. And when it comes to the issue of getting a better understanding of the national context, as Judge Darian has said, we always have recourse to the margin of appreciation, because for us, we are the second level when it comes to human rights enforcement. We will step in when the national courts would have entertained such application or alleged violation. It is when the applicants are not satisfied with the decision at the national court level that they do approach us, because we are very serious. The African Charter is very concerned about the exhaustion of local remedy. And what the African court would then do is to examine the process that the domestic courts have adopted in assessing whether there was a violation or not. So vis-a-vis the charter itself, we put side by side with what they have done, and this time maintaining international human rights standard. When we do find that the international human rights standard has not been conformed with by the local domestic court, then we can find a violation or an infringement of such a right. In our case, in this discussion, the right to freedom of expression in the form of humor. So in effect, what I'm saying is that we look at it in a case-by-case method. We would rely on what the national courts have done, but still monitoring and examining conformity with international standard. And what is the international standard? The international standard has been set clearly in the charter itself. We have the 3-part test, which we would use to evaluate. We also have the Ramad plan of action. We look at the context, we look at the content, we look at the speaker, we look at the intent, and we look at the likelihood of the statement or the humor itself being provocative, being inciting any form of violence, hatred, public disorder, public morality, and the common interest of everyone. Because your right stops when the right of another starts.
So I don't know if you wanted to have one final sentence sum up before we opened it to the rest of the panel, or I have a particular question if you'd like to hear that. This is actually for both judges from the international courts, and that is, I see you both have a margin of appreciation, right? There's this sense of deference to the domestic national court as to, for example, the findings of fact. And I wonder whether the extent to which you, in applying international standards, defer to the particular findings of fact that pertain to the notion that the humor has been offensive to the particular national sentiments, whether that's part of what you defer to, or whether that's really not something that's included in the margin of appreciation.
Okay, who's going first?
Whoever wants to go first.
Okay, please, Judge.
Thank you. Thank you. That's a good question. I think that is a mix. So of course it has factual elements, but it may also have cultural elements, historical elements. For example, the Sinkova case was described, which was decided by the tightest of the margins that we have at the chamber level at the court 4-3, and you had the two sets of opinions. But irrespective of what you think the outcome of that case should be, you need to understand how that fits within the Ukrainian historical context. You know, what is this monument about? Why they felt at the national level that the frying of an egg over it was could be perceived as offensive to people who are look at it as a monument of a certain sacrality and respect for the fallen over an historical period, and so on and so forth. So I guess the short answer to your question, I think it is that implicates a mix of both facts, but also a first legal assessment that is done at the national level. It deserves a certain level of deference, but the higher the level of protection under the convention, for example, for political speech or public interest speech, the narrower that margin will be. On other kinds of speech, if it's commercial speech or let's say some sort of lower value expression, the margin will be larger. Okay,
Judge.
Yes, I just quickly to add that we do know that universally certain statements may be found provocative and repugnant to good conscience, equity. That will also come into play. That it is a peculiarity in a national context does not absolutely isolate it from that test. The test of universality, the test of will the reasonable man anywhere consider that particular humor as provocative, as repugnant to good conscience, as something that cannot generally be tolerated. That test could also factor in. So in effect, before a court like mine and any other court indeed, we arrive at a decision, we will consider so many issues. You consider the evidence before you. You also consider the position of both parties, because normally you have two parties before you. You listen to what the applicant have to say. You also listen to what the respondent state has to say. And then you also draw inspiration from practices that are a bit similar, and also cases that have been decided before. So all this considered together, we enable the court to determine the justice in the case.
Very good. Does anybody else on the panel have a comment? Yes.
Yeah, maybe a comment on what has been said so far is, first of all, I kind of disagree with this characterization of margin of appreciation. I have a problem with the whole concept, and in my experience, it often becomes this like ritualistic formula and rhetorical device which is applied very inconsistently and actually leads to very confusing sort of case law. But I don't think we have time to talk about it. But what I think is important for humor and different to international framework as compared to African and European system is the approach to hate speech and incitement. Because incitement standard is based on the International Covenant on Civil and Political Rights, which is not replicated in the regional conventions. So you don't have the same obligation under European and African system to prohibit the certain hate speech in the same level, right? So that's why actually shows very varied and confusing, sorry about this, confusing case law as it relates to hate speech and incitement from European court, because they are interpreting it differently as the international standard. So I was actually wondering what Darian and Stella would say about this, because in your jurisprudence, you can restrict much more than what would be possible under international standards.
Yeah.
Because similar obligations do not exist under the European Convention or African Charter. Yes, and for Darian.
Okay, the restrictions, I believe, are very clear, but it's just a question of interpretation. And when interpreting the restrictions the way they are, we know, the issue of national security, public order, public morality, public health, as well as the common interests of everyone beyond your own beyond the personal interest of the author of the humor. We will be guided, I believe we'll be guided by the fact that your interest, your own personal interest or whatever you want to achieve, your intent, it will still take us back to the assessment we talked about before, which is the already established standard using the Raman plan. We want to look at the context. Mm-hmm. So in analyzing the context, you'll be able to derive whether or not this is suitable, this is appropriate, this is decent, this is not decent, this is provocative, this is harmful. And then you also look at the intent of the author of the humor itself. Is it meant to provoke? Is it meant to tarnish the reputation of someone, a target group? That also will be considered. And then we look at the audience and we look at the spread. So all these are the standard, international standard that have already been determined that will be used to assess whether truly there has been a violation or not.
Mm-hmm. So Judge Pavli, do you have a comment?
Yes, I mean, one reaction is that I think that the question is a bit circular in itself in the sense that we like to think that the European standards are part of the international standards. So if the court comes up with a certain interpretation of the convention in a particular case that informs the international standard, if by international standard we mean the International Covenant, Universal Declaration, then we have to go with the interpretation of the UN Human Rights Committee. Do I think that there is a big gap between how the Human Rights Committee interprets incitement compared to the European Court? Not necessarily. There may be differences. I don't necessarily think there's a major gap. The convention, the European Convention, does not have the equivalent of Article 20 of the ICCPR, which requires prohibition of propaganda for war, but it is something that the European Court often cites in its case law when it comes to, let's say, the most harmful forms of expression, and we have a doctrine under Article 17 of the Convention that exempts certain extreme forms of speech altogether from the scope of protection of Article 10. and that's why I think they come together.
Okay. So now I have a question, direct question for Dr. Bukovská. And it's based on your experience with Article 19 and working with the organization. And it's a broad question, and that is, what are some of the unique challenges that humor poses for free speech jurisprudence?
Mm-hmm. Yeah, thank you, and also thank you so much for invitation to be part of this project. It's important for me, not just as a part of Article 19, but also, a Czech person, and we pride ourselves in being this, having humor in our DNA, quite wrongly, I think, but thanks to our politicians, actually. Now we are the laughing stock of Europe, so probably rightly so. But also for Article 19, it's we obviously deal with restrictions on freedom of expression, on freedom of expression, which would fall into the category of various types of humor, as was outlined in the toolkit. But I think also Darian said that the panel decided that this was quite a serious matter, and I would also say that although it says that laughter is the best medicine, the examples from our work and from the toolkit show that it's quite bitter pill to swallow. But what I want to highlight is probably add on some issues which were not specifically mentioned in the previous presentations, which come in our work. I think that we should keep in mind that restrictions on freedom of expression and form of humor do not come just through legal means. They also come through physical attacks and often in an ultimate price in terms of losing life. So, for example, Charlie Hebdo example shows that 12 people actually were killed for engaging in freedom of expression in form of satire. We also saw example of Danish cartoons, those behind Danish cartoons, or even more recently in Slovakia, a humorous site, Zomri, has been on a receiving end of severe physical attacks. So protection from this type of attacks is something which we shouldn't disregard. Then in terms of the legal attacks or legal restrictions, as I see it, it comes not just from the states, and that was described quite in a detail by Alberto and by other speakers, but also from a lot from private actors. We obviously spoke about the social media, but also comes from private actors in the realm of education, in the realm of employment more and more, and also in a kind of cultural setting, broadly defined as this fight on woke or a war on woke, but obviously it's not limited to that, and also there's restrictions on cultural expression in books and removing even some, bad jokes from it. So the attacks come from numerous sides, not just from the state. Then what haven't been highlighted in the previous panel was that when we look at restricting humor, we need to go through three-part test, and Alberto and others look at the balancing act under the third prong of the test, under the necessity and proportionality. But I would also put emphasis, and in our work we also see it, that we need to look at the first two prongs of the test. So we need to look at whether the restrictions are defined with sufficient clarity and allow people to regulate their conduct appropriately, and this is not the case. And often you have these vague, overbroad laws which restrict freedom of expression, and obviously then when it comes to humor, they will also be applied in a broad manner and restrict the speech in a form of humor. We can look at the laws prohibiting glorification of terrorism, prohibiting speech against politicians, extremism and so on. So that's on that first bit.
So we have one more minute.
Yeah. On the legitimate aim, that also often doesn't meet the test of legitimate aim, because when restricting humor, they don't really pursue the protection of, let's say, protection of reputation or protection of national security, but really trying to shield politicians and others or a state from deserved level of scrutiny or from just restrictions rather than really pursuing national security, genuine national security. And it comes also to the laws as insult, criminal defamation, blasphemy, which actually have no place on the books and should not be allowed. So you wouldn't need to balance the necessity and proportionality, but you should not have this as a legitimate aim. And then I can just add to what has been said on adding these complications to how the humor is being restricted on social media, because the social media companies and digital companies, they have totally different standards rather than what is in international law. And it counts not just for the context, but also in terms of resources. They don't, for context and for cultural context, they do not invest sufficient number of moderators who would understand this, outsource everything to AI, which is not really prone to understand and to distinguish between humor and other forms of expression. So that's just briefly touch on this.
Okay, great. Does anybody have a comment and reaction? We can move on to our UNESCO representative, Mehdi Benchelah. And it actually picks up on the last topic that was mentioned, and that is content moderation. So we're going from a much more narrow lens, much more wide lens to a much more narrow lens. And we know humor intersects with various problematic forms of humor: hate speech, incitement, misinformation, disinformation, and the like. And content moderation obviously attempts to touch on that, but I was interested in the standards that UNESCO may bring to bear in identifying and curing some of the major pitfalls in content moderation and those particular types of problematic speech.
Thank you, Laura. So yes, UNESCO has been working a lot with judicial system, first of all, on international standards on freedom of expression and safety of journalists. So how to raise awareness of judicial actors on these standards, and how to give decisions which are more in line with international standards, because in many cases judicial actors don't have always the knowledge of the regional convention that their states sign. So we did a lot of work with the courts, with the regional courts, the African Court on Human People's Rights, for example, to work with judges, prosecutor, in order to give them more granularity when they assess a specific case related to freedom of expression. And in some cases, I have to say, we in our workshop we also raise the cases of humor, because they are very interesting and they bring very interesting challenges. And the idea is to have this dialogue with these judges. So this has nourished a lot the reflection for us in this work. I wanted to touch base a little bit on this work because I think it's essential. Regarding the content moderation, and so UNESCO also has worked at the Secretariat on these guidelines for the governance of digital platform. It has been quite a long process involving a lot of actors and civil society, government, journalists, media, and the platform, of course, themselves. And these guidelines really, because they really highlight the importance of having a more centric process approach and multi-stakeholder approach in this, because the risk is, of course, to have content moderation that will stifle freedom of expression too much. That might seem very interesting at first. Say we're going to fix this problem with this expression that can be dangerous or harmful, but you create externalities. So how to strike a balance is very difficult, and really the highlight there is to have this multi-stakeholder approach, to have all these actors involved: government, civil society, platform, journalists, users, in order to have a better approach. Also to also call on having more transparency for the digital platform, to accountability, human rights approach and assessment, because this is very important, and concurrently leveraging on the capacities of the different actors to ensure that the freedom of expression standard will be safeguarded, including the humor. I think that's, in a nutshell, the guidelines are available online, and they are a document, living document. It's possible to look at it more in depth. So that's, in a nutshell, I will speak about that. Thank you.
So one of the things that we have talked about over the last couple days is the divergence between what is lawful and what may, in fact, violate the particular standards that are used in the content moderation. And I was wondering whether there's anything in the UNESCO guidelines that directly address that, or whether the idea of protecting sort of human rights as a general matter is a way of moderating between what the digital platform is requiring in its content regulation and what international standards are imposing.
Yeah, because they are not supposed to abide completely by international standards the same way that states,
sure,
because
sure.
they are private actors.
Right.
So it's a little bit different in that way. So the approach is a little bit different, but yet, I mean, we encourage them to apply the international standards, the Article 19, the three-part test, which makes that the restriction should be legal, they should be based on legitimate grounds, and necessary and proportional, where most of the cases on the problematic case come on this issue of proportionality and necessity that we've seen. And to use the Rabat Plan of Action, which gives also various sets of of criteria which are very, that are, I think, very helpful for them to assess the different cases.
And I would think that the encouragement of transparency also
Yes.
helps in that. Does anyone else have a comment?
Yes, I think when it comes to platform, we need to also distinguish between the sort of market power or the market dominance of the platform, rather than treating them in one broad sweep. There's a really difference between what Facebook does as compared to, I don't know, Mumsnet or one of the smaller, even like, you know, if For Hume decides to have a, you know, social media sort of interface and, you know, people to comment, that will have a different content moderation rules. But I think what should be common to all those platforms, large and small, should be the clarity in their content moderation and community guidelines to clarify what is allowed and what is not. And then there should be the consistency of the application of these community standards, which again is a problem, especially for those big companies. And then the transparency of how they make the decisions. So I think that this often is lumped together with this lawful but awful or illegal or not legal content, because the platforms can allow on it, can restrict on their platforms much more than what a state can restrict under international standards. So if they decide that they want to have their platform friendly to children, or if they want to target certain groups, it's perfectly fine. But consistency, clarity, and transparency should be the guiding rule for all of them.
And if I may add also the remedy, because there is a big problem there, is that honestly it's kind of a black box. It's very difficult to have a possibility to communicate why your account has been suspended or this post, etc. It seems that it's very difficult to have a clear answer, an reaction, and why. And in some cases to have remedy. And that's with anecdotal example, which are like even a state account on the platform has been removed, and the state, I'm talking about, a state has to issue a press release in order to have an answer from the platform in question, to have somebody contacting them, because they couldn't get any answer. So that's a little bit interesting to have this kind of example to show that the possibility of remedy and communication is extremely important too.
Mm-hmm.
No?
I mean, 2 quick points. I would say looking at recent policy developments in Europe, the concern is not so much that the platforms are doing too much to protect people from harmful speech, but if they're doing too little, in part because their business models create incentives that go against them taking action to protect people from different forms of online harm. And the second point I would make, which is, it goes along the lines that of the last point that Mehdi made, was we need, on the other hand, counterbalances that allow individuals who are being, well, literally, or if you want in inverted commas, censored by the platforms to have some kind of remedy, some kind of due process, for the simple fact that it's possible to think of them as purely private actors. They are, in a way. I don't think it's realistic in our current context. They have become too important for public discourse to treat them as your supermarket or your pharmacy. They are now very much part of our infrastructure of public discourse.
I totally agree. I'm troubled by the power, and I think I'm not alone in being very troubled by the power of these so-called private platforms that have become the main street where we exchange ideas as a public forum. And I don't necessarily have an answer except to point out that with the advent of more dispute resolution mechanisms within, like the oversight, that they're looking more and more like a governmental entity, and it's not clear to me the best way to go. That is, should they be treated as a state, or should we try to develop a new paradigm, a quasi-state paradigm based on the power of the private entity?
I mean, we have precedents. I'm not saying that it's the same identical thing, but we have had for many decades special legal regimes for broadcasting because of their special power, directness, and first of all, because of the scarcity of the spectrum. Now, that no longer applies, but it is an interesting historical parallel to a dominant media that, because of its exceptional power, required and justified a particular set of regulations that wouldn't necessarily apply to print media. And so, yeah, we are not without precedents entirely.
Any other comments?
If I can ask to Darian, the justification for the regulation of broadcasting media was the scarcity of the public, the airwaves, which were limited and were belonging to the public. Was it more this, or was it their power in terms of the capacity to influence, etc.? Which was the most important according to you?
I think it was a combination. Maybe it started with scarcity. The scarcity gradually became weaker as an argument in technological terms because there were it became less scarce. And they didn't rely directly on the electromagnetic spectrum. But then the dominance, I think, became a more important factor. Now, of course, you have historical differences. In this country, you had the fairness doctrine for a number of years, and then it was repealed. Right. In Europe, the fairness doctrine is very much alive and well. We still have a fairly comprehensive and detailed regulation of broadcasting, and it is still considered an important medium, at least for my generation. Maybe not my daughter's generation. It will probably be a very different outlook. But yes, we still, because of their directness, their outsized role in shaping public opinion, access to news for a large number of people, we still consider it justified to have special regulation for broadcasting.
It seems to me that the access question in terms of access to the people to express an opinion and a point of view is very different in the social media context than in the broadcast context. And it seemed to me that a lot of the initial regulations were in fact focused on the lack of access of a speaker to getting their message out through the use of broadcast. So it's a sort of a different challenge when it comes to social media.
In some ways, yes, but being thrown out of Twitter is that is denial of access, and
Right,
it's
right.
quite significant in this day and age. So yes, we don't all. We have, in general terms, we have. There has been a democratizing effect, and a lot more people have access, unless the platform decides that you don't have access. So.
Okay, so I think we have a few minutes for questions from the audience, either the online audience or the people here. And I am going to look at my moderators for any of the questions that may be coming across online.
Okay, this is a microphone. It's not working.
We can hear you.
Yeah, we can hear you.
So it seems to me that one of the interesting things is by looking at humor, one raises literary questions. What's the relationship between literary ways of thinking about the issues of opinion formation, violence, conflict, etc. So I want to suggest that the panel ask how, this is really in a way Article 20 and propaganda for war, which we talk about. Is there a different mode of analysis where the shapers of information are really playing a literary long game? I think of Russia and the question of how to impose or achieve, quote, family standards, a long effort at transforming the way the community thinks, etc. The same thing could be happening in the United States or other societies where powerful organizers are looking at this question of how to shape attitudes, what I've sometimes called a market for loyalties. And it's not clear to me, well, it would be interesting to look at the Oversight Board and its request for comments and its analysis of comments to see whether there's a shift in terms of the arguments that are being made, the information that's thought to be relevant, etc. I've enjoyed the panel because it provokes these kinds of questions.
I'll just make a few remarks and see if anybody else. You covered a lot of ground in that question. I'll first start with the observation that I agree with you, that there's a literary component to humor in terms of expression, that it presents a challenge that we don't always see.
Just, I'm going to plug it for my wife. This is the tortoise and hare metaphor. So does that do much more work more quickly than the framework that exists on humor and law?
That is the ability, that has long-lasting ability to govern. Well, so my point was that maybe we do want to take a more cautious approach. One of the things that we settled, given that we're humor scholars, it's pretty obvious, it's in our self-interest, is that there is something to learn from rhetorical, linguistic, literary studies in evaluating the impact of humor. It's very tricky. as opposed to other forms of communication. And I think you were alluding to the fact that humor can very much work under the radar to manipulate opinion when in fact it's not always so obvious. So that's my original response, but I wanted to invite other people on the panel to respond.
I mean, one point I would make, again, there were a lot of things to unpack in Monroe's question, but I think one thing that humor has in common with, well, it is a form of art for a lot of people, at least in some forms of humor. And I think one thing it has in common with good art is that it tends to go against sacred cows in our societies. And sacred cows are different nature. They could be of political nature, it could be of moral, religious nature, and that's how people engaging in humorous expression often get in trouble. And I can see this dynamic that as some groups of parts of societies may prefer or engage in efforts to generate more sacred cows, then that creates more problems for the disparaging and the satirical vein among us. And it calls for protection.
And just like, the bit on propaganda, which is very interesting because that's very unexplored sort of field in the free speech community and free speech, jurisprudence as well. I mean, when we work on propaganda, we approach it from the point of view of right to information, and that people have a right to even receive this information from hostile state, and also you have a right to receive this information, and even to some problematic expression. So I didn't look at actually, and it's something maybe you can put in the, and again, your project is big, in the toolkit from right to information and right to receive the content from propaganda point of view, because I don't think it's really restricted, or people are restricting that. It's more nefarious sort of content, or propaganda for war and so on. So something really to look into. But when we look at propaganda, we look at it from the right to information.
Do we have any more questions? Any questions from the?
I'd just like to say that the question of how to make a cow sacred and how to rethink the world in terms from the perspective of the cow.
So I think that might be it. Do you want to wrap anything up?
I have only one last quick question. The question is quick probably, but the answer might be longer than the timing of the panel might warrant. I just wanted to go back to the intersection of humor and cumulative harm, so harm that does not amount to direct incitement to violence, discrimination, but when used systematically might little by little contribute to creating a climate of hostility towards a certain group. And this type of harm was also referred to as symbolic violence in a recent, was a concurring opinion to the case Stella de Abreu and Portugal at the European Court of Human Rights, but yet to my knowledge there isn't yet a well-established jurisprudence on a European level at least about specifically this intersection of humor and symbolic violence. I was wondering, I was curious to hear more about your respective views as to what would be the best way to tackle this type of symbolic violence, whether that should be by means of rethinking the notion of incitement on a legal level or through other means, a combination of the two, or So this is very much of an open question in that sense.
On incitement, and again, this is international, how on the ICCPR we look at it. I think incitement to discrimination, and well, incitement to violence is the kind of easiest one because you can really see what is the likelihood that violence is going to materialize, like how is the audience going to respond. This incitement to discrimination is a little bit more difficult because how do you prove that it's going to happen? But this humor and incitement to hostility is something which actually should be further explored because that's utterly unused aspect of the Article 20, paragraph 2. And actually, if you look at the travaux préparatoires, the reason why hostility was included is quite interesting, and it means different things to different people, and that kind of was sort of a compromise why it was included. But that's definitely something which is relevant to humor. But I haven't seen any case law on this because people just don't raise it because they look at discrimination and they look at violence as the easiest bit. Obviously, European court and regional system doesn't go through the similar assessment, so they just look whether it violated rights of someone or whether it violated public order or like national security and so on. So that component is totally missing. But maybe if there are more cases brought to Human Rights Committee under this rubric, it will be different.
Any other comments from the panel?
I think one area I think we may have to also look at from the legal or from the judicial point of view is the proportionality when it comes to the law, for example, restricting the right to freedom of expression. Most time, the cases that have come before the African courts, the issue has always been the fact that the penalty is disproportional. Either it's too stiff, like in the case of the popular case of Agabere versus Rwanda, where the applicant was sentenced to 15 years imprisonment, having been tried and convicted for the offense of on the grounds of like freedom of expression offense. And the court felt that, yes, it was right for the court, for the state to restrict the issue of any speech, any form of speech or any form of expression regarding the offense, regarding genocide, because the country has just come out of a very horrific genocide experience. And then the speech, the issue that was at stake before the domestic court was the fact that that speech could warrant some kind of incitement, internal strife, and there was need for the state, again talking about the margin of appreciation, for the state to ensure that they preserve order and security. And then the speech was interpreted to be the speech the lady made, the applicant made, in the Rwanda Genocide Memorial Center, and at the time she also made it, because the country was just coming out of genocide, that terrible genocide experience, was most insensitive. It was capable of generating more strife and more dispute, more disagreement, amongst the people. And for that reason, she was convicted, she was found guilty and convicted and sentenced to 15 years imprisonment. When it came before our court, we did agree with what the National Court said in finding a violation, but we said the penalty was totally disproportionate with the crime, with the criminalization of her speech. And for that reason, we asked the domestic court to have a review of the sentence in a manner that it will not be disproportionate, in line with the in line with Article 27 of the African Charter on Human and People's Rights, which recognizes restrictions, but still it has to be proportional, using the three-part test. Thank you.
I think what was very interesting in the discussion we had during these days was really the role of humor and cartoonists and people doing satire and as what we talk about lifting a bit of the, how to say, social pressure valve that they could allow the society to laugh at itself about some issues, and somehow I think they are on the forefront of the limits of freedom of expression in many cases, and this frontier is not fixed, it's moving. We can see that along the time. We now accept things that we didn't accept 50 years ago. So they are on the front line, and sometimes they go a bit too far and they get heavily sanctioned for that, which is, and there is really also two contexts, I would say. There's the context of humor in terms under authoritarian regime, where they really have an important role for challenging the powerful. Often, in some cases, it's the only way. It was the only way to tell a joke like this between people, between family, which is a way to make fun at the unbearable situation. And so it has a very important societal function that we should not forget. I think for very courageous people paying a very heavy price. We can see that in very heavy prison sentence in many countries. So I think that, and then there is the case of the humor that, of course, that crossed the board by attacking and citing certain groups, and that's also, it needs to be addressed, but with respecting freedom. So.
I think the analogy to the phenomenon you described that you can find in the U.S. is reference to something that was named spirit murder, and the idea was that a series of disparaging comments can have the effect of, by analogy, death by a thousand cuts. And it was a way in the academic literature, at least, that people were advocating that we should change our approach in the United States to hate speech, that it is something that could be regulated, and the regulation could be controlled, justified in part by this idea of spirit murder to particular elements of society. Mm-hmm. So I think we may be out of time. And we really appreciate your attentiveness, and there's some refreshments over there, and thank you to the people online.